This is Hubwonk. I'm Joe Selvaggi. Welcome to Hubwonk, a podcast of Pioneer Institute, a think tank in Boston. On August 9th, the U.S. Court of Appeals for the Fifth Circuit issued a landmark ruling that could substantially alter how law enforcement conducts investigations in the digital age. The court declared that geofence warrants, those orders that compel tech companies to provide data on all devices within a specified geographic area, are unconstitutional under the Fourth Amendment's protection against unreasonable searches. The case at the center of this decision, United States v. Smith, involved three men convicted of a 2018 armed robbery of a mail truck in Mississippi. The Fifth Circuit ruled that geofence warrants are unconstitutional, owing to the size of the nearly 600 million user database being searched. This decision marks a profound shift in the legal treatment of digital privacy and stands in direct opposition to a ruling just last month by the Fourth Circuit, which upheld the use of geofence warrants under certain conditions. The Fifth Circuit's ruling not only creates a circuit split, but also signals a potential Supreme Court showdown that could redefine privacy rights in the digital era. What does this ruling mean for the future of digital privacy in the United States? How will this decision affect the way law enforcement agencies operate? And what might happen next as this issue potentially makes its way to the Supreme Court? My guest today is legal fellow in the Cato Institute's Robert A. Levy Center for Constitutional Studies, Brent Skorup, whose research area includes free speech, technology law, Fourth Amendment protections, regulation, and property law. Mr. Skorup will discuss the facts in the U.S. v. Smith case, the split the ruling creates with case precedent and the Fourth Circuit, and the limits of searches as technology evolves to record every detail of our movement. He will share his views on the long-term implications for criminal investigations and technology should the Supreme Court hear this case in the future. When I return, I'll be joined by Cato Institute's legal fellow, Brent Skorup. Okay, we're back. This is Hubwonk. I'm Joe Selvaggi, and I'm now pleased to be joined by legal fellow in the Cato Institute's Robert A. Levy Center for Constitutional Studies, Brent Skorup. Welcome to Hubwonk, Brent.
Thanks for having me, Joe.
There's a lot to understand in this recent Fifth Circuit ruling in U.S. v. Smith. I want to talk about how it informs our understanding of privacy, the constraints of warrants and searches, and frankly, the nexus of our very connected world with the power of the state. So I want to start at the very beginning and look at our shared right, our constitutional right against unwarranted searches. Where does that right come from?
So the Fourth Amendment to the Constitution provides that Americans have a right to be secure in our persons, our houses, our papers and effects against unreasonable searches and seizures. And we also, any warrant that issues must be supported by probable cause and particularity, describing the persons to be searched and the things to be seized. So fundamentally, this, what's often called a right to privacy comes from the Fourth Amendment and our protection against unreasonable search and seizure.
Okay, so we have a right. I'll just quote the Fourth Amendment here for the benefit of our listeners. It's in our Constitution. Quote, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause supported by oath or affirmation, and particularly described the place to be searched and the persons or things to be seized. So that's pretty powerful, pretty concise. We have a right against unreasonable search and seizure. And I think if I'm hearing what you said accurately, that what is reasonable is based on probable cause and some specificity as to what is going to be searched and what might be seized. So without this right, I just want to sort of frame it even more specifically. Essentially, this was, say, our founding fathers' resistance to this notion that you could just knock on a door and toss a house looking for any kind of evidence of a crime. In other words, no such thing as a general warrant, which would grant police the right to just go around looking for evidence in a possible crime. Is that fair?
Yeah, that's right. The Fourth Amendment was put in place. It was foremost on the framers' Constitution in their memory of British officers and the Crown's officers just ransacking houses looking for evidence of wrongdoing from citizens of the U.S. colonies. So this was foremost in their mind. They wanted to prevent so-called general warrants, which basically just say, crime has been committed and officers can just ransack a bunch of houses looking for so-called wrongdoers. So the Fourth Amendment prevents that.
That's right. So, okay, so we've sort of set up the principle here. So let's get into the specifics of what what the Fifth Circuit decided. The Fifth Circuit Court of Appeals decided last week. The case was U.S. v. Jamar Smith. I'll just say, for the benefit of our listeners, I'll sum up sort of the high level what went on in this case. We have a mailman who got robbed in Mississippi, and the investigators had very little to go on as far as leads. Share with our listeners the important facts in this case.
Yeah, so as you said, a contractor for the U.S. Postal Service was mugged. He was unloading bags of mail, much of it had cash in it. He was mugged by an assailant, presumably a man. Sprayed with pepper spray, was struck by a handgun. The assailant threatened to kill the mailman, took the mail bags, and within the mail bags were $60,000. And then the assailant fled in a vehicle. The police had some surveillance video. I believe a local commercial establishment had some grainy video. As police saw some cars circling the area where the mugging occurred. They saw a man who appeared to be on a phone prior to the crime, but aside from that, they didn't have anything go on.
So this is a pretty bad crime. I think they got something like $66,000 out of the mailbag and very little to go on. But as you mentioned, the surveillance saw a phone involved. So I don't know if that had any effect on the prerogative to go to a third party, in this case Google, and ask for a list of accounts that were near the crime scene. They had no names. They just knew when this crime had occurred, where it had occurred. What happened next? What did the investigators do when they went to Google?
So the Postal Service investigators, as you said, it came on dead ends. They couldn't, with the grainy video, they couldn't really identify who it was. However, the investigators heard about this fairly new investigation technique called a geofence warrant, which has been growing in popularity, I would say, over the past 5 years. So a geofence warrant is a little unique in that in a traditional warrant, your police officers are specifying, a home they want to search or a person they want to search. With a geofence warrant, the police are specifying a geographic area that they want to know who is in a geographic area in a particular time period. And almost all geofence warrants go to Google because many of us have Google phones or use Google affiliated applications that provide GPS tracking. And so police over many years have been getting these geofence warrants where they go to Google and say, tell us who is in this area, a city block or whatever, within, a 2-hour time span, as an example. But that's the basic of it. And I can talk more about geofence warrants, but they went to Google. The U.S. Postal investigators said, tell us who was around this area of the mugging in this particular time period.
So we've got a lot of new vocabulary words here. I had to learn in this case what geofence was, but I suppose it's geography and fence, sort of, a metaphor for what's going on here. They're figuring out who's in a particular, let's say, space circumscribed, perhaps a circle or a rectangle, a city block, right? I'll provide our listeners with another bit of vocabulary. Google has something called a sensor vault, right? It has nearly 600 million active accounts. That's people like you and me who have cell phones, but those might be attached to our Google accounts or to some of the applications we use. And all of them show where we are. Again, I was in reading the case, I see that Google's accuracy is often within 6 feet. It can determine what floor of a mall you're on or in a building. So it's pretty accurate stuff. So in this case, the investigators go to Google and they say, let me know who might have been or who was in this space at this time. Describe for our listeners, what did the investigators have to do in order to, let's say, justify or legally compel Google to share this data with them? What steps, what hoops did they need to jump through?
Yeah, so the geofence warrant process, even to those like me who follow this area closely, was a bit mysterious until fairly recently. We now have a couple court cases explaining how the geofence warrant process works, there's three steps involved. So law enforcement, they'll go to a magistrate, a judge, and seek a warrant, a geofence warrant. Yeah, they've got to have some evidence, some particular evidence about why they're searching a particular area, a geofenced area, but they'll get a judge to sign off on it, and then they'll give this warrant to Google. As I said, other companies as well, but it's typically Google who has this geolocation information. And so there's three steps. At step one, police say to Google, we want to know who is in this, city block or whatever, from in this 1 hour time period. We want to know all the accounts who are there, but provide search all your records, but provide us a list of anonymized accounts. That's step one, where they give that warrant and the instruction. I want to emphasize the information they're requesting is anonymized. It's a artificially assigned device number or something, but police just want to know a rough idea of how many people are there. So that's step one. At step two, police single out some of those anonymized devices, and they go back to Google and say, these few devices interest us. We want to know where these devices were outside the geofenced area, and typically they again provide a limited time. They say, 2 hours outside the geofenced area. We want to know where these devices went. So it's a narrow list from that first, from step one. Again, this is anonymized, and then finally at step three, police again have narrowed down the list, based on where these accounts were going, in a broader time period outside the geofenced area. They then narrow it down and go to Google and say, these couple accounts interest us. Tell us their usernames, their IP history, and their names if you have it. So again, step one, instruct Google, go through all your records, tell us who was in this area for this short time period. Step two, the subset interests us, tell us where they went before and after the crime. And then step three, when they've narrowed it down further, when police have narrowed it down further, they say, we want to know names and account numbers for these people. And that's what happened in this Smith case.
This again, my spidey sense is tingling here, in that the government now is able to essentially say who was where when. There's no promise that any of these bad guys had Google tracking, right? There's no. This may have all happened with them out having turned off all their tracking on their phones, or not have their phones at all, perhaps. So this information can pick up everybody, just somebody walking by on the street, somebody committing a different crime that just got caught in this sort of dragnet. Are the police doing this now? Is this sort of now something commonplace, or are we on the cutting edge?
It's fairly common. That's safe to say. I wouldn't go as far to say this is the kind of their first step for law enforcement, but it is fairly common. I mean, I haven't seen recent numbers, but as of 2020, Google was getting about 12,000 of these geofence warrants annually, in the year 2020. So that's a couple dozen a day on average. They're getting these geofence warrants, ranging from very serious murders all the way down to vandalism in some cases, stolen wallets and burglaries. So it really runs the gamut. But yeah, as our most recent records show, local and federal law enforcement are seeking a few dozen of these geofence warrants per day.
Well, I think digital privacy is an issue for a lot of people. I will admit, if for our avid listeners, I don't cover the issue very often in the last 4.5 years of doing this podcast. And for me, I'll admit, I'm somewhat comfortable with the idea that Google or Facebook or my credit card company, for that matter, knows what I'm up to, because I enjoy their services. But they're private entities, private companies. This seems to me to be a nexus between the information I freely give or share with my internet providers, and now the government, which also would have access to know where I am at all times of the day. This to me, again, we're talking about 600 million accounts in this this searched database. This makes me a little bit uneasy, the government having access to this. In this case, let's get back to the case U.S. v. Smith. It also made the judges in the Fifth Circuit of Appeals uneasy as well. Say something about their observation or their perception of the constitutionality of geo warrants.
Yeah, so I mentioned the three-step process that law enforcement went through here with Google. Through this, police found two suspects that, based on the records that Google had turned over to them, they found two suspects, and with this geofence information, they then got a traditional warrant. They then knew account names, and they went to Gmail, and they went to a phone provider for additional evidence. But initiating the case was this geofence warrant, and then they got more evidence. So that they eventually arrested, and I believe all three were convicted at trial, based in part on this geofence evidence. And so the three suspects here alleged that this was a deficient warrant, this geofence warrant, and therefore all this evidence against them should be suppressed, because essentially all the compelling evidence against them wouldn't have been gathered had this geofence warrant not been issued. So the Fifth Circuit, so again, they were convicted at trial. The suspects appealed to the Fifth Circuit, and the Fifth Circuit took a look at it and agreed with the suspects. They said this warrant is deficient. It resembles that general warrant that we talked about. This British practice of just ransacking houses with a general warrant. The Fifth Circuit said this has a lot of parallels to it. The Fourth Amendment is designed to prevent these broad searches of information of places just to find wrongdoing. And so they said the warrant's deficient. And they, this is a side, kind of an aside, but they did allow the evidence to stand in this case. But in future cases, the police can't use these geofence warrants in the Fifth Circuit.
Right. So I think the facts in the case, just to be clear, Mr. Smith still goes to jail, but it's based on the fact that the information used, the police thought at the time it was fair to collect. So they made an exception in this case, so to allow the evidence. But their observation from a constitutional perspective was this search was too wide. I want to just clarify one thing. They weren't saying that the warrants weren't properly done, and again, in the steps, but rather the database they were searching is too vast, right? This is essentially saying, if I'm interpreting this correctly, any geofence search warrant is sort of a general warrant because of the massive amount of information one needs to scan in order to find the needle in the haystack. Am I right with that?
Yeah, that's right. The court here, the Fifth Circuit here, said that initial request to Google is a search, which is a little interesting. We'll talk about it in a bit and how that differs from the Fourth Circuit case here. But they said that the initial step, the request to Google to search all their customer records, is a search by the government. And they said this so-called warrant is equivalent to a general warrant, and said it's just facially deficient and cannot be valid. No, Google cannot be compelled to search based on a geofence warrant.
So this creates what we call, or what you call in the legal world, a disagreement, a conflict between two different Court of Appeals, the Fourth, which had recently decided a case, and the Fifth. Let's just do a little bit of sort of background here then. I think it was recently, maybe a couple of months ago, the Fourth Circuit ruled on a particular case very, very similar to this, called US v. Chattree. I think I have that right. And they took similar evidence and found the exact opposite, which is to say the search wasn't unconstitutional, largely based on the narrowness of the information that was sought. Share with our listeners the general information or the general features of that case, and how it's different, and ultimately how the Fourth Circuit decided in a different way from this Fifth Circuit of Appeals.
Yeah, so the Fifth Circuit, covers the southern region that includes Texas, and Louisiana, Mississippi, and the Fourth Circuit covers the Mid-Atlantic, where I am, in Virginia, and some other Mid-Atlantic states. But the Fourth Circuit, so the Chattree case was a very similar case. It was another crime. This time it was a bank robbery, and like the Smith case, police, their investigation went cold. They couldn't identify, they know a bank robbery occurred. They know which vehicle, which direction the vehicle headed, but they didn't have much more to go on than that. And so they in Chattree, police went to Google with this geofence warrant, said, we want to know who was at the bank at the time of this robbery. And then they went through these 3 steps again. The initial request for Google for anonymous ID numbers, this narrowing of devices, and then police asked for where these particular devices went outside the geofenced area for 2 hours, and then based on which ones looked most promising, then they asked for the count and names of device users. And so but the Fourth Circuit came to a different conclusion than the Fifth Circuit, and created this circuit split about geofence warrants. They said it was permissible.
Yes, so we've got this split, two similar cases and different determinations. We know how the courts work. We know how judges are supposed to work. They look at precedents, and as you mentioned at the top of the show, this is new stuff. We didn't have Google and smartphones at the founding fathers' convention, so we've had to apply, let's say, old ideas to new technology. When we look to precedents and we say, okay, how should we think about this in this modern world? What is an illegal search in a modern time when we have what used to be ephemeral information, where we were, when we were, now is memorialized forever in some database? What did the courts look for similarities in this case to support their decisions one way or the other?
Yeah, and I confess, the precedents here are can be hard to find a coherent line between them, but there is some precedent here that you often see in these geofence cases in particular. Courts look to, well, so there's a court-made doctrine called the third party doctrine. And this came about from some court cases in the 1970s. One, U.S. v. Miller, involved police acquiring bank records of a suspect. I believe, suspected of financial crimes of some sort, but they got bank records without a warrant. And there was another case called Smith v. Maryland, where essentially what we might call a wiretap of a phone, without a warrant to see who a suspect was calling. In those cases, the Supreme Court of the United States said information that someone, that you or I or anyone, is voluntarily turning over to a third party, like a bank, like a phone company, we've got to dial numbers into our phone where that has to be sent to our phone company so they can complete the call. Any information we voluntarily turn over to a third party, we lose our expectation of privacy in that. And when the government acquires that information, it's not a search, and the Fourth Amendment does not apply, and thus no warrant is required. So this third party doctrine has been quite powerful, and quite powerfully limits our privacy expectations, because we turn over a lot of information to third parties all the time, even sensitive information. However, I will say, we have these older cases, and the court is applying this to this new world of digital information. I'm sure, many listeners are familiar with just how connected our world is now, just everything on our phones, on our work computers, on our personal computers. A lot of this is being stored in the so-called cloud. It's being stored on servers far away, on third-party devices. And and the Supreme Court is struggling with how to apply, does the third party doctrine apply to this new digital world we have? Um, and the court in a case called Carpenter a few years ago seemed to indicate, where digital data is not like the bank records in Miller, it's not like the phone number dialed in Smith. Digital information is a little different just because it's so vast and it reveals so much about us that if law enforcement could get that without a warrant, that would eviscerate all the privacy expectations we have. In this case called Carpenter, so this involves police getting without a warrant cell phone tracking information, which provides not quite as it's a little blunter than the geofence information we're talking about, but it does provide location information, our cell phone records. So, and the Supreme Court said when law enforcement wanted a week's worth of cell phone location information about a suspect without a warrant, the Supreme Court said no, you need a warrant if you're getting cell phone location information from a phone provider. And so it's a little in flux, but Supreme Court has said digital information is different. The third party doctrine does not always apply.
So, drilling down a little more
Yep.
carefully into the notion of search, is the issue at hand here whether the entire database is the scope of the search or whether the very narrow, meaning perhaps everybody would agree that you couldn't simply say, geez, I think this is a bad part of town. I'm sure crimes are being committed. Give me everybody who's walking in and out of this bad block or bad neighborhood, that would be considered a general warrant. How specific are we talking about when we're splitting hairs? If I'm trying to make heads or tails of this idea that I want to be able to access this very valuable information, but I want to, in good faith, protect the notion of privacy, how would I tailor it, or what would the court say about how narrow the warrant would have to be to pass muster on everybody's constitutional scale? Do you understand what I'm saying? How do we have to sort of shape these searches to comport with the Fourth Amendment?
I would say as of today, we don't know. This Chatry case and the Smith case, I believe are the only time federal circuit courts of appeal have dealt with these geofence warrants. And neither court provided, a helpful response to your question, like how specific does it need to be. The Fourth Circuit in Chatry said no search had occurred at all. You don't even need a warrant. So there is no particularity or requirement laid out. In the Fifth Circuit, as I said, said that this is a general warrant. It's just facially deficient. I could speculate about what would satisfy the Fifth Circuit's particular, what would be particular enough for the Fifth Circuit. But it would just be speculation on my part. But you could imagine a narrow search, but it would be difficult to know based on these existing geofence processes how you'd make that particular. I don't know, maybe, yeah, I don't know. Yeah, more limited time period, a smaller zone. I don't know.
Yeah, well, I'm good. I kind of set you up for this next question, which, of course, when we have a split, our listeners know because we've dealt with this before. When we have a split in the Court of Appeals, the next step, I suppose, would be if the Supreme Court grants cert in this case. Is that right? Where they will ultimately answer my question more specifically, which is to say, if Smith is, all Google searches are unconstitutional, and the Fourth Circuit, which says it's not even a search, let alone one that requires a warrant. They're going to, I guess, consider taking this, and they would effectively then be charged or tasked with making a decision, answering my question, which is what constitutes a constitutional search of online data like this, geofence data.
Yeah, so I should add, and I think you mentioned both these cases. The Chatry case came out in July. The Smith case came out a couple weeks ago, a month apart. And it may work through appeals. I believe the government is seeking, an appeal in the Fifth Circuit on the Smith case. So it's not the end of the story, but I do think a case like the, I mean, I think an issue like this will get to the Supreme Court eventually. I think there probably will be a circuit split at some point. I mean, there is, today. And so how will the Supreme Court approach it? The core issue, I mentioned that three-step process that Google goes through. To me, the big difference between the Fourth Circuit in Chattree and the Fifth Circuit in Smith is at that step one, where law enforcement has this so-called geofence warrant and goes to Google and tells Google, search all your 500 million account records, and tell us who is in this geographic area. The Fourth Circuit said that's not a search at all, because Google is doing the search. The government is not doing the search. It's just instructing Google to do the search, and that's not a search at all, according to the Fourth Circuit. The Fifth Circuit responded actually to the Fourth Circuit in a footnote. I wish they made this part of their kind of main body of their decision, but they said, based on Supreme Court precedent, that requiring a private party to do the government's business is still a government search. I mean, you could eviscerate all kinds of rights if the government can just compel a private party or work with a private party, say a government contractor, to do unconstitutional things. So Fifth Circuit, I think, has a stronger end of the argument. They said, no, step one is a search. This request that Google search its records is a government search. And the Fourth Circuit just said, that's not a search. That's not a government search. No warrant is required. So I think the Supreme Court has to address that. Is a geofence warrant, is that a search or not? And that's the core disagreement between the two circuits.
Indeed. So I want to again challenge you and go a little bit out of your expertise, perhaps, and say, okay, let's imagine then if this goes down, as you say, if the Supreme Court is more sympathetic to the Fourth Circuit's perspective and say that provided Google does it, it's not a search. I think that Google, in my mind, this has got to be bad for business, which is to say, if this becomes sort of common knowledge that all your geopositioning information is now up for grabs from the U.S. government, they'll know everywhere you've been, every moment of your life. The reaction naturally, I would imagine, would be Google would want to somehow limit that. They don't want to be party to this. I hope they don't. And then individuals would be more diligent about turning off their location. And in a sense, the world becomes less efficient. I won't know as I'm driving down the road where the next gas station is, or I won't know all kinds of things that I enjoy because Google knows where I am. And Google will lose some power to provide that information. What do you see as the sort of logical, technical reaction to discovering the government can now suddenly have access to all your geopositioning information from the day you were born?
Yeah, well, I'll make one caveat. I believe in both these cases, the suspects had volunteered for Google to store their location information, so they opted in, and this was relevant in these cases, or at least the Fourth Circuit, which said, when you voluntarily turn over, and here where you opt in to ask Google to collect your location information, you can't claim a privacy interest in it. So I will add that, although to your point, Google still tracks, even if you don't opt in, they still track all kinds of location information. It's not quite as extensive if you don't opt in. But yeah, sorry, you're getting back to your question.
Yeah, I mean, will Google likely, create some sort of barrier that, essentially either prevent the government from getting this information or stop tracking, make it difficult for these non-searches to even occur?
So the interesting thing on that note is you're exactly right. Google does not want to be an arm of the government, and Google does, take privacy of its users seriously, and it came out in both these cases that Google, and this has been publicly reported, during oral arguments of the Chattree case a few months ago, Google announced they will no longer be storing people's location history as they have in the past. And I believe in an off-the-record interview, a Google employee said in part that was because these geofence warrants have been a huge headache, just a PR and logistics and just a privacy problem from perspective of Google. So to your point, Google is taking steps to restrict what information they have on their customers because the executives there are quite uncomfortable with their need to respond to these geofence warrants.
So, as you say, we've got a split. It's a very recent split. I don't know. I'm not well versed in how the Supreme Court works. If this is going to have cert granted, when would that occur? And then when would we, see this on the docket for the Supreme Court?
Oh, yeah. I mean, that's again, I can only speculate. And again, I know in the Fifth Circuit there might be further litigation here. But I would, yeah, I mean, maybe this is my own, bias, kind of, research in this area. I think, this is very important stuff. But yeah, I could see a case like this reaching the Supreme Court, particularly if there's a circuit split in the next 2 or 3 years. But again, that is pure speculation on my part. And the issue would be, like I said, is this a search at all? When despite Google limiting what information they have, they still have a lot of location information. And it's not just Google. Other apps we use daily track location information. I mean, Uber and Lyft and all a bunch of other app companies have our location information. So, just because Google is limiting some of its information does not mean geofence warrants are going out of fashion. I know if anything, law enforcement is learning more about the capabilities of geolocation information. The fact that these records go back, 5, 6, 10 years, it's just too much of a temptation to look at the information and solve crimes. I think it comes from a healthy desire to solve crimes, but of course we have that can't go too far, particularly when it's as broad as a geofence warrant.
That's right. And I remember, I forget who said, "Show me the man, I'll show you the crime." If you had everybody's data forever,
Yep.
you could find something wrong in anybody's past. Well, this is exciting that, again, there's a bright future for those people who are in this area studying the law, studying the constitutional features implied by the Fourth Amendment. So I guess you've got a lot of exciting work ahead of you. I want our listeners who are interested in this topic to know where to find you. You're at Cato, of course. Where can our listeners go to read, either from the Center for Constitutional Studies, the Levy Center for Constitutional Studies, or your work in particular? Where can they find you?
Yeah, you can find a tab for the Center for Constitutional Studies at cato.org. I'm fairly active on Twitter. My handle's at @bskorup. And yeah, I would add, I'll pitch. I'm working on a piece about these two cases and a related case in Colorado, where Colorado Supreme Court found that people have a possessory interest in their digital records, and that's the Fourth Amendment protection of digital records. So there's a lot of interesting, important court cases in this area that I'm writing about, and I hope listeners will check it out.
All right, well, watch this space. I hope I've piqued some interest in this topic for our listeners, and you've been a great asset, a fund of information, and I think taken a very complex issue and made it more understandable for our listeners. Thank you very much, Brent. You've been a great guest.
Thanks for having me, Joe.
This has been another episode of Hubwonk. If you enjoyed this program, there are several ways to support Hubwonk and Pioneer Institute. It would be easier for you and better for us if you subscribe to Hubwonk on your iTunes podcatcher. It would make it easier for others to find us if you offer a 5-star rating or a favorable review. Of course, we're grateful if you share Hubwonk with friends. If you have ideas or comments or suggestions for me about future episode topics, you're welcome to email me at hubwonk@pioneerinstitute.org. Please join me next week for a new episode of Hubwonk.